Now, a former Attorney General of the Federation and Minister of Justice, Michael Aondoakaa, senior advocate of Nigeria, has been a man in the eyes of the storm in the wake of a controversial test of a meningitis antibiotics vaccine on children in the northern Nigerian city of Kano in 1996. Mr. Aondoakaa had been accused of receiving kickbacks amounting to $6 billion from the deal, an accusation he continues to deny while insisting that he knew nothing of any attempt to investigate him. Mr. Michael Aondoakaa, senior advocate of Nigeria, joins us now for a chat in the light of the release of fresh evidence by Kano state government on the matter. We also intend to pick his brain on EFCC's path to probe state finances and moves being made by some states to establish their own anti-graft agencies. Good afternoon, sir, and welcome to Newsday.
Yeah, good afternoon.
Very good. So, these accusations on the Pfizer vaccine settlement and Kano's fresh evidence, what's your response? And, of course, your alleged involvement. Can you give us a background as to how this came about?
Well, thank you very much. And also I have to thank the Almighty God. The document released by Kano, which is dated 4th October 2009, clearly exonerated me. The document was copied to me as only for information. Read it out. He said the quality just for me to note. The Kano state governor wrote and signed himself to the then President Yar'Adua that they have settled everything with Pfizer and clearly stated how much was paid to each person. Said 35,000 for the victims, 35 million for the dollars for the victims, 30 million to Kano state government, 10 million still to a reimbursement to Kano state government for public funds to defend the action. The authors show that Kano state set up its own committee headed by former Chief Justice of Nigeria, Justice S.A. Begoro. And then the second committee was also set up by Kano state government. So I have no hand in it. It's simple. The document is all over. It speaks for himself. I think this will put to rest the accusation that I received anything from Pfizer. Kano state government did their negotiation. The committee members are there. Whatever that was paid to them is there. And incidentally, Kano state government copied. Let me read that portion that is very important. He said, the foregoing is for your information, guidance, and record purpose. That is, the governor of Kano State wrote and copied me and said it's for my information, guidance, and record purpose. So how do I come in? So I think we don't need to waste much time on that matter. The matter is already completely settled with the release of that document from the appropriate authority.
And just to tie it all up, what do you think was the motive in roping your name into this entire saga?
I really don't know. I really don't know. And that is the price you pay for service in government. I did not know, but I have a feeling that it's because Pfizer wanted me to drop the case, not to grant fiat to the respected Yemi Osabanjo, who was lawyer to the Kano state government in the criminal trial. I was to grant them a fiat so that they could be able to arrest the people, and I should also invoke the legal assistance treaty to bring the directors of Pfizer from U.S. for prosecution in Nigeria. So that must have been the reason they wanted to blackmail me. They did more than that. They hired people to investigate me and try to rope me into things I never did. But now it is vindicated. God has known that I am not part of it. I was not part of anything.
All right.
Incidentally, nobody is directing any question to the Kano state governor as to why he spent the money. He is there. Ibrahim Shekare, so I'm not involved.
All right, it's good to know that we've cleared that up. And of course, if we could delve into other issues, let's talk about the EFCC and state-owned anti-graft agencies, the nature of their prosecuting cases. Don't you think there will be jurisdiction challenges here, especially when serving, and of course, former governors are being fingered on allegations of corruption. What exactly does the law say about issues of jurisdiction regarding EFCC in prosecuting state-related cases, you think?
Well, it has been a controversy that started during the time of ICPC, when the then Reverend Rotimi Williams challenged the jurisdiction of enacting ICPC. He felt that the offenses were state offenses, and he tried to get it, but on the general common intention to eradicate corruption, Supreme Court, in their wisdom, gave judgment. But I want you to understand that all the offenses that the governors are being accused are also, if it's not our offenses, under the penal code. And effectively, a state can also, does not even need to start another agency, but can prosecute them under a former governor of the state. Can be, prosecution can be initiated by the Attorney General of that state under the penal code. All the investment, corruption, all of them are under the penal code in northern Nigeria. And in southern Nigeria, they're under the criminal code.
All right, still on that question, you also mentioned the Attorney General and, of course, the penal code, as it were. But I would like your take also on the state legislature, to make governors accountable, for alleged financial, malpractices, as it were. How can we link that to what the Attorney General has to do here with regards to that?
They can amend the penal code to give more greater powers. The State House of Assembly can amend the penal code to give greater powers. This is coming particularly because it's worrisome by the governors. They appear to have a feeling that there has been a kind of a deliberate attempt to rob them or unfairly disgrace them after leaving office. Let's take the case of Yahaya Bello, the drama that happened in Yahaya Bello, where there was an attempt to arrest him by EFCC. Where I decided to, because of this interview and because of my trying to give public enlightenment on this channel, I tried to dig into the matter. I think the controversy was unnecessary in case of Yahaya Bello. This was some of the things that are coming out unnecessary. There was an ongoing case which Yahaya Bello sought to enforce his fundamental human right. It was based on one particular case which EFCC amended a charge and included him. That is charge number 550/2022, pending before the Federal High Court in Abuja. At the accusation in that charge, I think there was an error by EFCC. The error was that he was being robbed there because he was governor, but they referred 2015. Conspiracy for him to conspire with one Bello in 2015. 2015, the man said, I was not even a governor. I was a governor in 2016. That was a premise he went to enforce his fundamental human right before a state high court, which the state high court and the federal high court have concurrent jurisdiction to enforce fundamental human right. When he enforced the fundamental human right, there was interlocutory order restraining EFCC not to arrest him pending the hearing of the case. Of course, he was governor that time. He had immunity. But as times went on and the case came to conclusion on the 17th of April 2024, I think the judge, Justice Modipe, he gave a considered judgment on the originating summons brought by former Governor Bello against EFCC. The judgment was very clear, and it was, to me, I've seen a copy of the judgment, it was like a win-win situation. The judgment said, yes, I've granted your fundamental human right for the case pending before the court at the Federal High Court instituted against you filed charge number 550/2022 before Justice Omotoshi, you should not be arrested. You should not be detained. Since the matter is in court, the court should serve you someone to appear. It's there in the ruling. So it is not pending in the court. It's for the court to serve summons. And Aja said the summon can be sent by DHL. So once it is no longer for the EFCs to get him arrested, it's the direction of the judge in the Federal High Court here with the final determination of the case by the Kogi High Court. With that direction, it is the judge that we now say, look, serve Yahya Bello summon, or I issue bench warrant to get him arrested and brought before me to stand trial. Charges have already been done. So I think EFCC, the attempt happened before the judgment. So I think they will study the judgment and do the right thing. After all, the current leadership seems to be following the law. He's a lawyer, and he will do the right thing. Then the second aspect of the Kogi High Court says that if you want to have any additional charges to file against Yahya Bello, don't arrest him, but file him the charges in court. And so once charges are filed in court, the agency cannot arrest. It is the court that will issue the summons and serve on Yahya Bello, and it's the court that will now, if he doesn't show up, the court can issue bench warrant for his arrest. The moment the bench warrant is arrested for failure to appear to answer the charges against him, which are already before the court, then the agency can go to arrest based on the bench warrants. So I'm thinking, and the most wisdom to do in this matter is to follow the order of the court, of the Federal High Court. I don't even see it's necessary to appeal the order. But because I see the order being well balanced, the case in the Federal High Court of 2022 is already pending. So if it's pending, you can't come and arrest, except the court gives an order for you to go and arrest. And at that time he was governor, he had immunity. Now he has left office. EFCC can go to the court and apply for summons to be served on him to come and appear and answer that charge case, which was instituted in 2022 before Justice Omotoshi. The other ones, if they have anything, they can go on and file in any court. The judge is any superior court. Now, once you file charges in the superior court, the agency cannot go to arrest.
Okay.
What the agency will do is that it will get the superior court will issue summons to the defendant to appear and answer the charges. It's when he fails to appear that the agency will apply for a warrant of arrest and get the person arrested. So I think after the confusion, the judge in his wisdom clarified this confusion. And I believe EFCC will read the ruling which was delivered on the 17th of April and clarify this. But these are some of the issues that there is strong agitations by the states. And I think that we should now, way forward, try to take steps that we mutually not try to create a crisis that states, because they can also have the power to amend the penal code and start doing their prosecution. It will defeat the end of the corruption.
Right. Let me step in before we shift our attention away from this case concerning Yahya Bello. Thank you so much for unpacking it in a very technical way. So the issue on the ground is that the general public who are observing this are not really privy to these very technical details, and a lot of people may not even really understand. What a lot of people see is that there was a standoff between a former governor and the EFCC, and that there's some form of stalemate happening. And, the questions happening are, there are two questions. First of all, why does it seem that this former governor can get away with anything? However, that's not the case. You've clarified that. However, there's another side to the story, which is that people are asking, so who does EFCC report to? Who is ordering Olukayede to pursue this? Because he initially said that there would be no media trial, and then we saw a press conference where he said, we called him, and the former governor said we should come to his village and so forth, which sort of felt like a media trial. So the question at the end of the day is, who does EFCC take orders from?
Well, the EFCC ought to take orders from the Constitution of the Federal Republic of Nigeria, and the enabling law. And the only people that interpret the enabling law are the judges. In this case, the only order the EFCC will follow now is the order made by the trial judge of Kogi High Court, which gave direction of how EFCC will proceed to arraign Yahaya Bello. Of course, they have done the arraignment. In the case which was 2022, they have filed charges in court. He is no longer a governor, so he can be prosecuted based on the charges they have filed. And once charges are in court, it's no longer the agency that will arrest, it's the court that will issue summons against Yahaya Bello. And when Yahaya Bello does not appear, then EFCC will apply to the court for a bench warrant to bring him to come and answer charges. These are the steps he has to take. In the subsequent one, the judge said, because of your antecedent, you should file charges in the court first and serve. The court will not serve Yahaya Bello, should come and appear. But don't arrest him, don't detain him. I think it's a very fair judgment. But the position of the law is this. It's not for me or anybody or any agency to interpret a judgment of a court. Where you see the judgment of the court is unfair, you go on appeal. Luckily, the Superior Court in 2021, the Court of Appeal saw this problem where some judgments of the lower court were very unfair to EFCC, ICPC, police, and they created a fast-track system, rules. The rules we rolled out in 2021. And the rules specifically made it easier for EFCC or police or any organization to approach the court in the Court of Appeal. Filing of briefs is only 14 days. Appellant brief. Filing of respondent brief is 10 days. Reply is 5 days. And if you default, you cannot be granted. Therefore, the whole trial on such appeal can be only less than 1 month or 1 month, 1.5 months, not more than 2 months. Judgment will be given. So you could see, it's better to have. The issue of having restraint is not because of the person. For instance, it's not Yahaya Bello. Yahaya Bello is not above the law. But it's the institution, the judiciary, we protect. I have a similar situation when I was a Minister of Justice involving Kano. Of course, Kano got court orders, and the EFCC felt strongly they should arrest them. Well, I knew, I had sympathy with them, but I followed the law. I said, look, there's a court order, go and vacate the order. And they went, incidentally, they went and vacated the order, arraigned Kano and got conviction. Even the conviction was affirmed by the Court of Appeal. It was the Supreme Court that quashed the conviction. Credit going to EFCC. And the EFCC under the current leadership is doing quite well. So we could not allow an issue of Yahaya Bello where court has clearly laid down procedure for them to follow. Of course, what happened took place before the judgment of the court, so I don't blame them. Now they must have got a copy of the judgment, and they will follow the procedure. For the case that is pending, ask the court to serve him summon. If it doesn't appear in the court, apply for court order. I'm interpreting it.
Okay,
for the second one, if you have anything against him, don't...
Our time is almost up. I just want to we just literally have 1 minute. I'd like to get your comment on this new movement by some states such as Lagos and I believe Adamawa and Kano to create their own anti-graft agencies at the state level. Just a very quick comment on that. Is that a step in the right direction, or are we moving backwards?
I told you, I even answered you before that they will be within the law. But you know where a law is enacted on concurrence list with state law, with federal law, the law of the federal law will prevail on such issues. But certain offenses are clearly under even not concurrently but residual list. The state has power to make their own inter-agency, anti-corruption agency. But in northern Nigeria, where you read the penal code, the state has nothing to go and create a new agency, but to amend those penalties that were ridiculously low, like £2, like to confine with the current income. Every single offense is in the penal code of northern Nigeria. And penal code is a state law. So all the state need to do, not to go and waste their time trying to create a penalty, but to amend the penal code and make sure that the law, the penalty is increased, restitution is increased, power to recover the assets taken by the governor or whoever is given in the penal code for them to prosecute the person at the state high court and recover their money. They can even make prosecution in jurisdiction or magistrate to try of some of the offenses where it's minor. But I will still tell you that the bottom line is that this apprehension which I alluded is the one that we create. And I would not want a situation that EFCC's powers is diminished. The state will have the power to make the law. But if the 36 state government have the power, it will diminish internationally the power of EFCC and the manner EFCC is doing to recover. Indeed. So at least some of these things, they should also try to address it.
Indeed.
Address it. I was also happy when my colleague said that he is not going to do trial by media trial. And I think he will rethink now that the judgment of the High Court of Kogi is very explicit about the procedure they should follow in this Yahaya Bello. I want to make you the bottom line. Yahaya Bello is not above the law.
Very good.
But at the same time, he's a Nigerian citizen, and they should follow the law.
All right. On that very note, I would like to thank you very much, Mr. Michael Aondoakaa, former Attorney General of the Federation. Thank you for your time.